Adding someone to title. So this is obviously something that you guys get a lot of. I get it every single day of the week. Every day, someone is calling, whether it's regarding a closing or a closing that just happened or whatever it may be. Every single day, someone's asking me, hey, can we do this? Can I add this person to title? Can we take this person off? Can we put it into my trust? Can we put it into an LLC? And this is a great class. This is a great topic to talk about because it really allows you to have an informative conversation with your client and, kind of understand what their concerns are, understand what their finances look like and why they would want to do certain things. And it gives you an opportunity to maybe become the expert again on a scenario. So if you can earn someone's trust because you get to educate them about something like this, I mean, that is the blessing. In my business, that's how I earn people's trust, is that they come to me with a request and I educate them as to why they would want that or not. And I don't just say yes. I don't just say, oh, you want to add your minor child to title. Let's do it. I don't just do it, take their money and move on. I actually say, okay, well, why don't you tell me a little bit about why, what's going on, what are you worried about? And then I, take all that information and I explain to them the rules. I explain to them what the statutes say and what maybe some of the downsides of doing what they want to do. And then I let them make the decision. Now that they're educated, what should we do? And that goes together. Kendra, Mark, and I, we talk about this a lot. One of my favorite analogies or acronyms would be IRAC, IRAC. So issue, rule, analysis, conclusion. So client comes to me with an issue. I want to add my child to title, or I'm worried about, probate or whatever it may be. They tell me what they want, what they're worried about, what they're concerned about. I tell them what the rules are. I say, hey, look, well, if you do that, here's the things that it's going to do. Yes, you'll avoid probate. That's a good thing. But you could have gift taxes. You could have this. You could have that. And then we say, well, for your purposes, this is either a good idea or it's a bad idea. And then conclusion, I'm going to let the client tell me that part. In conclusion, client, what do you want me to do? And, I talk a lot of people out of putting someone onto title. And I think that's what I'll leave you with or start you with, is that a lot of times I can find a really good reason not to do it, unless we are talking about a spouse. The spouse is the one person that I have no reservations ever in putting them on title or telling them not to worry about it, because there are a lot of Georgia laws that protect a spouse in those circumstances. So down and dirty, 30-minute topic. We tend to go a little bit over because we have fun with these classes, but definitely ask me about it if you want to focus on a particular subject. So avoiding probate, that seems to be the number one reason why you would put someone onto title. Let's talk about a scenario. My wife and I own a house, but let's say I'm the only one that buys it. So, or actually, I like this scenario better. My wife is the sugar mama. She buys the house for us. And she's the only one on title. She's the only one on the loan. And out of any concern for her health or safety, or just because we're partners, we're married, she wants to put me on the title. We would typically put the two of us on as joint tenants with right of survivorship, and it allows the property, upon either of our passing, allows the property to automatically convert into that remaining owner entirely, without having to go through probate, without going into an estate, really without any paperwork at all. So that leads to the first question, which is there are two ways to hold title when you have multiple people. It's either joint tenants with rights of survivorship, which would be what I would recommend for a husband and wife. They own the property. If one of them dies, the other one gets it entirely. Or tenants in common. So tenants in common doesn't do that. So if I were to pass away, well, the property doesn't merge into my wife by herself automatically. It actually goes into my estate. My portion of it does. So I pass away, my 50% ownership goes into my estate. So now if you get the listing and you go meet with my spouse, you're going to have to get her to sign individually for her 50%. And then you're going to have to figure out who the executor is for my estate. And it could be my wife, it could be my son, it could be my daughter, it could be my brother or my dad or my neighbor, it could be anybody. And so that's where it would require us to do a little bit more work. Now, obviously, if it's just a spouse, I get it. You don't want to have to do that in order to sell a house. You might have some financial obligations. You might not be able to afford the mortgage anymore, whatever it may be. That needs to be a lot more streamlined. And that's where joint tenancy with rights of survivorship. So we add the spouse, if they are concerned for tax purposes. That's one big thing. It's not a taxable event to add a spouse. Now, that is not the case with some of the other people that you would add to title. So that is a blessing. That's an awesome thing that the statutes allow for us, where if we add a spouse onto title, there's no taxes. It's not a gift. It's nothing like that for tax purposes. And so there's no real downside in that scenario to adding someone onto title. Also, we think about divorce occasionally. Unfortunately, it's a reality. And there are scenarios where, we add someone to title or we take someone off and we're saying, well, what if, we get a divorce, or, I want to make sure my spouse is protected or that I'm protected. What do I do? And the reality is, Georgia law for divorces does not look on whether you both own the property or not. If you're spouses, if it's marital property, it's marital property whether you're both on title or just one is on title. So again, there's no real downside to putting someone on title or not putting them onto title. So if my wife never adds me onto the title of our house, it's not that I'm giving up any sort of claim in a divorce. That, I'm 100% protected, assuming that is marital property, that we're contributing to this as part of the marriage, as opposed to me being an inheritance or some sort of separate property. We could spend hours regarding divorce law, but I just wanted to disclose that adding someone to title who's your spouse or not adding them makes no difference in regards to divorce, for the most part. So joint tenancy with rights to survivorship, adding someone to title, I almost never have any sort of hesitation to adding someone onto title. Additionally, the other thing that we think about is the loan. So in my scenario, I said that my wife has a loan on the house. She's the only one on the loan and she's the only one on title. Well, a lot of times, if we add someone onto title or if we take someone off, it can trigger what's called the due on sale clause. So the due on sale clause is a clause that says it's in your mortgage, and it says that if you convey any interest of yours out, so she owns it 100%. If she adds me on, that means she's giving up 50% of her ownership, or half, or whatever, some equal percentage. Or if she adds someone, or takes someone off. So if she's on it and she comes off entirely, in either scenario, she's conveying out some interest in the property, either in part or in full. And if you do that, generally the rule says you're in default of your mortgage. You're not allowed to do that. So there is an exception to that rule. Now, the result of that happening is if you trigger the due on sale clause, you're in default, and the lender can call the loan due in full immediately. That's a major problem. So if you add a child, if you add mom, if you add your neighbor or anything like that, or if you come off title, it triggers the due on sale clause, you're immediately in default to the mortgage and you got to pay it back. And the reason they have that law in place, and the reason why it's in every mortgage, is because they don't want you to sell the house and not pay them back. That this is a loan secured by the property and the borrower, and not some other person. So they don't want you to mess with that. They like the way they underwrote the deal initially, and if something changes, you got to pay them back. Except a few scenarios, and one of them is a spouse. So adding a spouse onto title does not trigger the due on sale clause. So again, you're protected from that scenario. So there's no gift taxes. It doesn't affect divorce in any way, and it doesn't trigger the due on sale clause, so it's not going to affect your mortgage. So again, I'm not seeing a whole lot of downsides into adding someone onto title or not. There is another scenario, liens. So let's say my wife is the great citizen and I'm the degenerate, as you may have assumed. And I've got all these lawsuits against me. I don't pay my credit card bills, and that's why I couldn't be on the loan in the first place. So in that scenario, if you added me onto title, all those liens come with me and attached to the house. And that's a problem. That's a major problem. Now, it's maybe less likely in the event we're married, because if one spouse is doing great, the other spouse is probably, keeping up, or at least treading water. But that's a concern that we might have more so for someone who's not your spouse. Say it's a boyfriend or girlfriend, or it's a just a business partner or something like that. You could have one really good partner and one not so great. Or if you put your child onto title and then he is, or she starts having problems, you know, that all affects your ability to sell the house, to refinance, to be able to, you've got these liens on the house and you just put someone on just to make, just to avoid probate. So spouses, again, I'm not that worried about one spouse having a bunch of credit card debt and the other not, because a lot of times those, finances tend to be commingled. So, if one spouse has credit card debt, they both do in that scenario, or if one's being sued, they're both being sued a lot of times. It's still a possibility that you wouldn't do it for that reason, but spouses, again, I'm not as worried about any sort of liens or loans or problems like that that could encumber the property. So we've got our probate issue, we've got divorce, we've got our liens and loans, we've got taxes. For spouses, I'm not really worried about any of those. And I'm sure I'll think of something else, some other reason why I don't think spouses should be something you concern yourself about. But you can now see, we can take those same items and we can look at, well, what if we do this? What if we do that? What if, all these different things. So the next line on here is more owners. So do not underappreciate the severity of your actions. You are permanently granting part of your ownership to another person. Again, if this is your spouse, I don't care. It's my spouse. We share everything. So all parties will have to sign the listing agreement, contracts to sell, refinance documents, and more. It is no longer a unilateral decision. Now, I read an article just this week. There's an article that's, I don't know how many times it's released a week, maybe once a week or twice a week, but I think it's called The Moneyologist on marketwatch.com. And they have these people who write in and ask financial advice. Hey, here's my situation. What do you suggest? And one of them was a husband who was trying to add his children to title to basically shield him from a lawsuit or something. Basically keep this creditor from taking the house or putting a lien on it. So he adds his daughters onto title. And this is really nasty, but the daughters never give it back to him. And I think that's just crazy, but it happens. And you just don't know. Maybe the daughters start judging you for, how you're acting, or, in this guy's situation that he was avoiding creditors. Maybe they didn't appreciate that. Maybe one of their creditors was the mom or something like that. Maybe they were getting a divorce. And the daughters, they just started making the decisions for him because they could. They had all the leverage. They were the ones on title, not him. That's a major issue. And he's no longer able to do things unilaterally. He can't make those decisions for himself. He needs to get his daughters to do it for him. I see this a lot more frequently with an older couple, maybe a husband and wife, or just one remaining spouse, and they add their children onto title as part of their inheritance. Hey, I don't want, I had to go through probate. I don't want my daughters or my son to have to worry about that. Let's just add them to title. There are a lot of closing attorneys and title companies that will do this without asking the important questions, and really mess you up in that regard, really push you in the wrong direction. On a personal aside, my dad loves to tell me, you're not getting anything until I'm 6 feet under. And maybe he says that a little more eloquently, but his point is, if I want to be reckless, I'm going to be reckless. I don't need your approval to do it. So I'm not adding you the title to the house, and then you not letting me do a reverse mortgage, or you not letting me refinance, sell the house, and travel the world with the money that I've accrued. It's my money, and I don't blame them. And I think everyone should act in that way, in a more selfish way. We don't always have to plan for someone else's inconveniences of probate. I had two other scenarios I wanted to tell you about in this regard. One of them was an accountant that I talked to, and she probably told me this 2 or 3 years ago, and she said that in her life, her grandfather had accrued a lot of property starting back in the 1940s, I think. He had bought and bought and bought, and he paid 5,000 here and 10,000 there, and over 70 years accrued quite the combination of real estate. Well, all those properties had gone up in value over the time, and now it was really worth something. So maybe he had a basis, what he paid for it, maybe 100 grand for all these different properties, but now it's worth $1 million over 70 years, and all the, adding things to the properties and all the development that's gone on. Well, as he's in his last few years of life, he starts thinking, all right, well, I'm going to add these 2 grandchildren to this property, I'm going to add my children to this one. And he starts divvying it up, and he starts adding people to title as joint tenants with right to survivorship. What she told me, now he didn't try and sell these properties before he died. He didn't do any of that stuff. What she did experience was that when he did pass away, they did not receive what's called the stepped up tax basis. So the stepped up tax basis is a current law for your estate. When you inherit property, you get it at the value. Your basis is what it is worth when you inherited it. So even though grandpa paid 5 grand, if it's worth 100 now when you inherited it, that's your basis. So if you go to sell it, your basis is 100 and your sale price is 100. There's no taxes, none. You don't get that if grandpa adds her onto title before he dies. In fact, what you get in that scenario is gift taxes. So he owns this $100,000 property solely. Well, now he's going to add Mary onto this, and now she gets a $50,000 gift, which is taxable, and she doesn't get the basis. So not only is her gift taxable, but when she goes to sell it, that's taxable as well, because her basis is the 5,000 or the 10,000 as opposed to 100. So she gets slammed with taxes, and over this entire portfolio, I think the grandfather made a $500,000 mistake by adding all these children to title in order to save some money on probate. Obviously, that's a mistake. You don't want to do that. And maybe your scenario or your client scenario isn't as drastic as that, but I'll give you maybe a more realistic scenario. You pay $350,000 for a house. You own it for about 10 years before you pass away. It's worth $500,000 now. You made some improvements or whatever, maybe the property just went up in value. So you got $150,000 of gain, which if you added your child to title before you passed away, their basis is $350,000, not the $500,000. So they're going to have to pay $150,000 tax, taxable income. And maybe it's a 20%, capital gains or something along those lines. And so your 20% of 150 grand is 30 grand. So it's a $30,000 mistake. Most probate, you can do it yourself, a couple $100, or even if you hire someone, it's $2,000. In addition, gift taxes, it's kind of a, something that you can account for a lot of times, but gift taxes can be 40, 50% of the gift. So if they give you, if it's a $500,000 property when they gift it to you and you're put on title equally, that's a $250,000 gift. And at 40% tax rate, it's significant. It's $100,000 or whatever it may be. So obviously that's a problem. And for a spouse, we don't have to worry about that. But for a child, for a neighbor, for a friend, for a business partner, those are major concerns. For an uncle, for an aunt, for a mom or a dad, any of those things are a problem. To go with those rights, the property may also be burdened by the baggage that each owner brings. So we talked about divorce, bankruptcy, liens, lawsuits, unpaid taxes, things like that, that all attaches. So you think you're doing a good thing, but now someone else's baggage is going to cause you pain on your house. And really, it's not their house, they're just on it. We talked about taxes, capital gains, and gift taxes both, so you can talk about that. And then number 4 here, probate isn't that bad. And I talked about this briefly, but let's talk about it a little bit more. So in Georgia, most people have a very simple and straightforward probate process. Forms are available online for filing by yourself or pro se. And I put a link here, which if you don't have the forms, you'll be able to get it after class. Even if hiring an attorney, the process takes 1 or 2 months and costs $1,500, $2,500 in most cases. So basically what you do is you or the attorney you hire fills out the form, which is made, it's public record. You fill out the form, you submit it, you pay the court costs, and assuming everyone signs off on it and the court approves the will that was submitted or that there was no will, the court gives you the approval to sell in like a month or 2. And that's not so bad. It really isn't. I know it's one extra step than you would like to have, but for all the other reasons, taxes and freedom and not having to be encumbered by liens or loans or any sort of issues, it's a lot better. It's the way you should be thinking about converting your property to your heirs or giving it in that sense, people inheriting it. It's really not that bad. So just some of the initial takeaways: adding a spouse has just a few negative issues, but we happily do this for people frequently. There might be reasons not to add a spouse. Maybe one of the spouses is a very prominent figure and they're trying to protect their privacy, or one of the spouses is the business person and has potential liens or litigation, and they would attach the house, and maybe we just want to keep that separate. But adding anyone else, be careful. For all the reasons above, it can be very problematic. And then if you want to add a child to a deed to avoid probate, I recommend it against it, obviously. But after careful consideration, you still want it, or you want to add someone into a title, you can go right to the website. And let me show you how this works. So it's campbellandbrandon.com/deed prep. So deed prep, there is it. There it is. So you click onto this. You cannot find it just by going to my website. You have to go specifically to this page. So campbellbrandon.com/deed prep. You click the link and you fill out your information. So who is the one giving you this information? What's your contact information? The address, tax parcel ID number if you have it, who the current owner is, and then what are we doing? Are we adding someone to the title? Are we removing someone from title, conveying into or out of a trust or an LLC, or transfers pursuant to a divorce? Those are all the reasons why you might want to do that. And what it does is it gives me all of your information up front so that I can start working on a deed, or I can at least call you and advise you as to what the upsides or downsides might be. So that's just campbellbrandon.com/deed prep. All right, so the first questions are popping in. So what happens with the mortgage if the spouse dies on a joint tenant with survivorship? Great question. Nothing. If you inherit the property or it's converted into your name, merged into your name as a spouse, you don't trigger the due on sale clause. So the mortgage cannot call it due. They don't have any right to call it due because you're now the owner as the former spouse. As long as you pay the mortgage every month, the mortgage company can't do anything. So there are a couple of things, a couple of reasons why a mortgage company could default you, and it would be, not the spouse. It could be not paying or, doing anything sort of like illegal or toxic at the house. The example I always give is starting a meth lab in the basement. They don't really approve of that. So nothing would happen, Norma. The other side of it is you can do a couple of things. You reach out to the lender and you actually fill out a form so that you get added as the main point of contact on the mortgage. So basically, the lender is not putting it into your name, but they're saying that you are now the owner and that you have the rights to speak with any representative regarding this mortgage because you are the surviving spouse. And you can always call me if you have questions about that. But essentially, your client or you would call your mortgage lender and say, "Hey, my spouse has passed away. He was the one on title. Here's the death certificate. We were joint tenants. Here's the probate if necessary, that sort of stuff." And then you'd have every right to talk to someone at the mortgage company, get payoffs and all that stuff. So it just kind of gets transferred over. So that's an excellent question. I love that. Let's see. I think she just had another question. So what happens if the son or daughter with the same name sells the property as soon as the owner dies before the spouse going to probate? Norma, that is it's an interesting question. And I believe that is something that is going on at the moment. It's fraud. So if someone else purports to own the property who actually doesn't, that is fraud. And that is why you get title insurance, because as a buyer, you may not know if you have the right person or not. And so you have to have title insurance as a buyer because you just don't know. The seller could know a lot about the property, live there, or, has keys and, whatever it may be, same name. And, as a closing attorney, those are the things that keep me up at night, verifying who owns this and who doesn't. And if there was a mistake made, the buyer needs to be protected. The buyer needs to have title insurance, because otherwise, if the closing attorney just did their best and they didn't insure title to the buyer, maybe they insured it to the lender, the buyer has no recourse. And so that's obviously a major problem. But that's a different one. So adding someone onto title, obviously you have to be as specific as you can regarding their name. So if it's junior, senior, or if it's a different middle name, we got to disclose all of those things. All right, so Shurston asked, with a spousal situation, why would a property ever be closed as tenants in common, as opposed to automatically be joint tenants with right of survivorship? We ran into this with my parents when my mom passed away, and most of their property was joint, but one or two properties were not. This is a great question. I'm glad you brought it up. In the 80s, maybe let's say before the 80s, joint tenancy did not exist. Georgia had to pass a statute adding it as a possible way to hold title. And I think they did that in the 80s, in the mid 80s. Before then, the only option was tenants in common. So if your parents bought one of these properties in the 70s or the 60s, or even if they bought it in the 80s or 90s, but for tax purposes decided just do it tenants in common, obviously it's a problem. And if it happened to you, it could happen to anybody. What I typically think of is, this is my process for avoiding this as a major problem. If I'm going to go to a listing, or if I'm going to sell a house, or if I'm going to even consult with a potential seller, I have to pull the deed, the whole deed. And I have to say on the deed that they are joint tenants with right of survivorship. Because if not, that needs to be a question I need to answer for myself. So I pull a deed, I see that they've lived there since 81, which is 40 years. Maybe they got married, they moved into this house, they started having kids, their whole careers, they retired, and now they're going to sell, they're going to move out. But maybe one of the spouses has passed away. We need to see the deed. We need to know, was it joint tenants with right of survivorship, or was it not? Did they never do that? Did they never update the title? And it's becoming less and less common for that to happen, but it's still going to be a thing for the next 5-10 years as those properties get sold. So I feel like I'm going to have to deal with this for at least another decade, which means you're going to have to deal with it for another decade. And you don't want to assume anything. You don't want to assume they were tenants or joint tenants when in actuality they were tenants in common. The only way to know that is to go look at the deeds. Pull the warranty deed, pull any deed that's of record, see the most recent one, and decide, does it say joint tenants with right of survivorship? So, it's not always safe enough just to look at the legal description, and it's definitely not safe enough just to look at the tax assessor website. To that point, let's look at one other thing here. Shersten says another question. So the only thing that made it less painful is that he was the executor of her estate. We provided that, and that was sufficient for him to be able to sell the property. So Shersten, you're right. If you want to be safe, if you don't have the deed, if you can't find it, whatever it may be, your answer always has to be, you have to probate the estate. You have to. But let's think about how that works. So husband and wife own the property together. The wife passes away, and we need to be able to start selling things. We have multiple properties, we have multiple bank accounts, we have multiple cars, we have all this personal property. You can set it up where you may not need to do probate, but I still would like for you to do probate as a catch-all, as like a last resort thing. So bank accounts, you can do joint ownership. So husband and wife, joint ownership. Cars, we don't really have to worry about that. Personal belongings, I don't think you have to worry about that. That's all just going to get divvied up. You don't need the court to necessarily approve that. The real estate, at this point, you can do everything joint tenancy. But if you didn't, then you would have to do a probate. And then life insurance, that gets paid directly to people. Brokerage accounts, you can have that paid directly to people. You can have joint tenancy. So you can do a lot of this stuff without even going to probate. But at some point, if you're the last remaining spouse, or if they're like in Shersten's scenario, there was a situation where there was at least one property that didn't have joint tenancy, you have to go to probate. And like I said, it's not that challenging. You just have to provide for enough time. That's the big issue. That's a great question, Shersten. That's excellent. So let's look at one last thing before we end. See if I can share the screen again. So let's look at Cobb. Let's look at the Cobb Assessor website. So a lot of you will get into the habit of just looking at Relist or FMLS. I really don't think that's enough. I would recommend you go directly to the Tax Assessor website, because the Relist and FMLS, they're pulling information from this website. And if it pulls it incorrectly, the information you see is going to be incorrect as well. So Relist is the least reliable place to get your information. The Tax Assessor is a little bit better, and then the Clerk of Court is the best. So that's kind of the process that I would go through. You can start at Relist just to get, because it's easier to find that information, but then I would start drilling down to get the best information. So let's say I already did my FMLS. I know kind of who the owners are, and I know my property address. And let's just start digging. Let's look at a property in Cobb. So the other reason why you would look at the Tax Assessor website, and you may recognize this, a lot of the counties in Georgia use qpublic.net, and they don't all have the same functionality for every county. I think they have to pay for different features, but Cobb County does a great job. They do an excellent job of using this. And so you could look here and see the owners. You say it's me and my wife. You can't tell if it's joint tenants or if it's tenants to common. It's not going to say that. And this may not be the most up to date. Maybe my wife just took me off the title because I'm a degenerate. Who knows? But we keep going down. You got your parcel number up here. Appraisals, you've got tax information, you've got my notice of appraisal right here, or assessment. So we kind of know what the house was worth most recently. You can pull all this information, pull information regarding the house, permits, were there any open permits, which I love. And then this is the part that Cobb gets right, that not many other counties have this feature. You can see the most recent sale. When I bought it in 2017, click the link. Here's our deed. I didn't have to log in. I didn't have to provide any sort of password, any of that stuff. And look here, here's our names, me and my wife as joint tenants with right of survivorship. So you know that if I meet my untimely demise, my wife doesn't have to probate my estate in order to sell a house. It's going to be hers automatically. And as a benefit, you got your legal description right here. So you got everything you would need. You can download this, you can print it, you can attach it to the contract, whatever it may be. Oh, looks like we may not have been sharing that. Let me just pull it up real quick. So you can see here my name, my wife's name, joint tenants with right of survivorship. It doesn't have to be right there. It could be anywhere on the deed. And sometimes you really have to search for it. But the safe assumption is anything, 90s and sooner is probably going to have joint tenants with right of survivorship. But you can't assume it. You actually have to do the research. You have to verify. So if one party has passed away, just call one of the attorneys at Campbell and Brannon and ask them to pull the deed and to double check, hey, how do they hold title? You may not need that if both my wife and I are at the listing appointment, but if I'm not there, you probably need it. All right, let's see. It looks like there might be another question. Where did I click to get the legal description? Okay, so that is, let's see. This is QPublic website. So we did our search for the property, and if you go down to sales, it's right here. And there's a click here button right on the last. So it says it's where it's recorded, and it's a link to the Cobb Superior Court website. But let's say it's not Cobb. Let's say we're going to go to Fulton, the Fulton Assessor. So this is Fulton County Board of Assessors. We're going to do a property search. And you have the option up at the top, owner search, parcel search, or address search. Let's just look for, let's look for one of these houses. I don't even know what I'm looking for, but this is the one. Hopefully it's no one here at this in this class. But obviously this looks a little different. This is not QPublic, but a lot of you are going to do Fulton sales just because it's the most prevalent place for sales to happen. But it's going to have all the same information as before. It's got your tax ID number, it's got addresses. If we go to the bottom, it has our owners. So it says Stephen and Melissa. It has their address. It has whether they're getting a homestead exemption. So it seems that they actually do live there. And then on the left side here, it also has a sales tab. And it shows every sale, every time the property has transacted over the last 10 or 15 years. So it goes back to 2006 in this case. And here's the most recent one, May 17. That's 2017, that is. And so we've got our seller, Michael Salisbury, to our buyer, Stephen Olson. But you notice there were two people on the tax record, so maybe that's not the full story. Maybe we actually have to look at the deed. And guess what? It tells you where to find the deed. It says to go to this deed book and this page. And it is a limited warranty deed. So that's pretty sharp. That's where I would start. That's what I would provide. If you're asking me to pull a deed, say, hey, can you get me this deed? It looks like the spouse may have passed away, and I want us to double check that it was joint tenancy or tenants in common, just to be sure. Now, high level, I would think that this is joint tenancy because they bought it just 3 years ago. But then what I would do is I'd be going on the clerk's website, GSCCCA, and you do have to have a subscription to do this, which if you have, you can pull it. But you do a search, we're going to do a real estate search, the book and page. So we've got Fulton, let's see. So there's our book, and it's page 119. I've got to log in, obviously, and I don't know my login. Let's see if I can get this right. If I can't, I apologize. Oh no! Hold on 1 second. Let's see if I can keep trying. Okay, I think I can get it now. I am not a robot. So this is what's going on behind the scenes in the event you are asking me for a legal description. So now by pulling that deed, this is what it's finding. But look, Stephen's the only one on there. I have a feeling if we keep searching, we will find where he granted it to his wife. So let's keep looking. So we're going to do a name search. His name is popping up 4 times. Let's look at the most recent one. This is where we add his wife. Yep, this is what it is. So now, limited warranty deed from Stephen to the both of them. Stephen and Melissa as joint tenants with rights of survivorship. So they are madly in love and they are on title together. We've got our title, got our legal description down here. All that tracker land being lot 2. So that's the process. That's what's going on behind the scenes. It's something that you could do if you have the access to GSCCCA, but in the very least, you can go on the tax assessor website. Sorry for the reflection. You can go to the tax assessor website. You can pull where the deed is, and you can kind of verify more and more of that information. There's one other thing I want to show you about before we stop. Let's go back to the tax assessor website. So we're here, we have our, oh, look at this. That's actually where the newest deed is. So I can't click on it for some reason, but the county has the order in the incorrect order. So see how the sale price is 0? That's where he added his wife onto title. It's just not showing me the right deed book and page. It's not letting me click on it. But here's the thing that is neat. We go to the map tab. This is a part that I just love, and every county has some version of it. This is called the GIS map. So it shows us property lines based on the tax map with a satellite image. So it's pretty sharp. So I can come in and I can get as close as I can as possible. There's our tax map that has distances, so 25 feet, 71 feet, 46 feet. It has distances, and it gives us a really good understanding. And one thing I can tell right off the bat before I even gone to the property is, looks like there's a joint driveway agreement. They're sharing a driveway. So I'm going to want to see that. I see a pool in the backyard. I don't see any improvements in the here, so I don't really have to worry about any encroachments necessarily, but that's what I'm looking for. Is there anything that I should be worried about? Look how close the house is to this property line. Does anyone have a survey? All that stuff. So we're getting a little off topic, but that's a really great feature on every one of these tax websites. Here's the one for Cobb. You just go to the top for map. And there's my house. And so again, houses aren't as close together, but we got some improvements that we have to think about. The driveway is close, but does anyone have a survey? You know, it's a good question to always ask. So I hope that was helpful.